On a scorching Saturday in September 2024, more than 30,000 people marched in South Korea's capital Seoul, demanding more aggressive action by their government on climate change. The march was prompted by a landmark climate ruling handed down by the Korean Constitutional Court just days before, which found the government's measures to fight climate change to be insufficient in protecting the fundamental and constitutional rights of its citizens. It was the first climate litigation case filed in South Korea and a historic win for climate activists. You are listening to Climate Court Voices, a podcast where we speak with the individuals leading crucial climate lawsuits and championing environmental justice efforts worldwide. In this episode, we speak with Sejong Youn, the attorney behind what became known as the Korean Litigation Case. He's a lawyer by profession, as well as the co-founder and director of Plan 1.5, a non-profit organization that advocates for better and stronger climate policies in South Korea. In August of 2019, a group of young climate activists organized as the Youth for Climate Action approached Sejong with what he said was a proposal he couldn't refuse. They were looking for a lawyer to represent them in a lawsuit against the South Korean government over its inaction on climate change.
The interesting thing about the case was it was the youth plaintiffs that were looking for lawyers, and they came to us. And every time they talked to a lawyer about potential litigation against the government, they said, well, it's almost impossible because we're talking about a long-term risk that may or may not happen to these individual plaintiffs. So legally speaking, all the legal requirements and legal theories, it will be extremely challenging to take it to the court. And when they came to us, I initially had the same idea about the possibility of a legal claim, but at the same time, every single thing they were arguing was completely correct. It was factually and normatively correct. It's a very legitimate claim. And if the law doesn't accommodate this type of claims, maybe the law is wrong. Maybe the interpretation of the existing law is wrong. Maybe the legal theories are wrong. Maybe it's a great time to challenge the existing legal theories and expand the boundaries of legal interpretation so these type of claims can be accommodated by the Constitution and the law. So it was something that could be done or should be done without changing the law itself because it's still within the boundaries of legal interpretation. And that's what lawyers are trying to do through lawsuits and litigations, and that's what the judges do to develop law. So we, after some contemplation, it really looked like it wouldn't make sense to refuse this proposal. That's why we started preparing the case together. That was summer of 2019.
On March 13, 2020, Sejong filed South Korea's first ever constitutional complaint on climate change on behalf of 19 young activists. They argued that the national greenhouse gas emission reduction target was too weak and infringed upon many of the plaintiffs' fundamental rights ingrained in South Korea's constitution, including the right to a healthy environment, the right to life, the right to health, and the right to equality, particularly of intergenerational equality. The legal team was specifically targeting the country's emission reduction target, known more formally as Nationally Determined Contributions, or NDC. NDCs are emissions reduction plans that each signatory to the Paris Agreement is required to update every 5 years to reflect their highest possible ambition in combating climate change. South Korea's target was revised months after Sejong filed a petition, from a 30% reduction from its 2020 business as usual level to a 40% reduction by 2030 compared to 2018 levels. The government also had a net zero target in place to achieve by mid-century, but lacked a plan and targets between 2031 and 2049. For the plaintiffs, the target was not only insufficient to limit temperature increases to 1.5 degrees, but it also infringed upon the right to equality of the young plaintiffs, because it unfairly burdened future generations with the responsibility to reduce greenhouse gases after 2030. But proving that the target was too weak wasn't Sejong's main problem. He and his team had to first make their case before the court, which never before was asked to rule on this topic, that climate change is a real and imminent threat.
It is not easy to build a case in climate change because the facts around climate change are actually quite complex. So our starting approach was we need to persuade the court justices that this is a serious problem, assuming that they have absolutely no knowledge of climate change. So we were trying to explain the scientific basis and all the basic facts, building from the scratch, as if we were talking to a middle school student, because we wanted to make sure everything was conveyed in a compact and easy to understand form. So we spent a lot of time going through the IPCC's reports and other scientific reports, transforming the scientific language into legal language and in layman's term, because that's what the legal language is. And so we ended up submitting dozens of submissions on science, recent events, and also developments in other countries. Whenever there is an important judgment or decision in other jurisdictions, we would translate it and submit it to the court before others would do it, because we thought we were doing the court's job on behalf of them. Because this is the type of case that the court addresses for the first time. And if there's no precedent within the jurisdiction, what does the court do? They start looking around and see what other courts are doing.
Because of the way constitutional litigation works in Korea, preparing for a case can be a quite lonely one-way process. To use Sejong's words, it's like talking to a wall.
The constitutional litigation in Korea is not an adversarial procedure, meaning it's not like the litigation we see on the movies. So we have our plaintiffs' arguments, but there are actually no defendants. So we are challenging the National Assembly with its law and the government with its policies, but they are only interested parties. They can submit their opinion if they wish to. If they don't want to, they don't have to.
And for the most part, they didn't. Sejong spent countless hours gathering huge volumes of evidence into long written submissions, but within the first 3.5 years, he and his team only received a fairly short response from the government once. For the most part, it was a one-sided process. To cope with stress, Sejong took on running and cycling, and even launched an Instagram page where he started cataloging plants around his office. Luckily, all the hard work and stress eventually paid off when court finally announced that there would be a hearing in early 2024. Between 4,000 and 5,000 cases are submitted to the Constitutional Court of Korea every year, but only around 10 receive a public hearing. The Korean climate litigation case was one of them. Despite by no means being a guarantee of victory, it signaled that the judges were taking the case seriously. It was the first significant victory for the Youth for Climate Justice group, who had spent the last 3 years raising the case's profile around the country. The group's young and fearless activists have been instrumental in shaping the climate movement in South Korea. Up until the group formed in 2018, the public opinion was focused on another environmental issue: air pollution. Climate change wasn't on many environmental organizations' agendas until Youth for Climate Justice brought it to the table, first with street protests and campaigns, then with the litigation.
When youth came up and started talking about climate change, it really kind of changed the dynamics and perspective, and they really played the pivotal role in raising climate crisis as the first and foremost agenda in the climate movement. So, and connected with that momentum, they filed the first climate litigation that gained a lot of public interest and attention, and because what they were arguing was logically correct and so legitimate, I think that also played an important role in increasing the public awareness of climate crisis in the following years. And during the time the litigation was pending, they did a really great job and worked very hard to maintain the media attention and the public attention of the case. So they were doing basically everything we could imagine. They were doing media events, demonstrations, school strikes. We also jointly held a movie screening, movies about climate litigations in other countries. They had online campaigns, so first anniversary, second anniversary, third anniversary, in September, climate strikes. So they were trying to use every single opportunity to maintain the attention. It's never enough, but one thing I can say for sure is during the time the litigation was pending between 2020 and 2024, the public awareness on climate change dramatically changed. There's a much higher level of social consensus on the need for action. And I think youth leading that voice and being the representative face of that claim, I think it played a really positive role because they are actually in the best position to talk about it because they have no economic or political interest in the matter. They were purely bringing this issue to people's attention from a justice point of view and normative and ethical point of view. And that is, it's actually impeccable in terms of its legitimacy. And it's about their family. Everybody has children, neighbors, their nephews. Next generation is always part of your life. So I think them talking about the future makes it more tangible, palpable, and relatable. And I think that was a very powerful piece that contributed to the general discussion on climate change.
Ahead of the hearings, the court consolidated Sejong's case with 3 other ongoing climate cases, all filed between 2021 and 2023, and all challenging whether existing government policies effectively protected the claimants from the threat of climate change. Ultimately, joining forces with other councillors made for one strong and successful case. On the 29th of August 2024, the court found the country's climate law unconstitutional on the ground that it breached the plaintiffs' constitutional rights to a healthy environment. Despite having set a net zero goal for 2050 and an emission reduction target for 2030, the law was silent on what would happen in the 2 decades in between. For the justices, this lack of sufficiently clear and concrete targets or plans for emission reductions between 2031 and 2049 would inevitably push the climate burden to future generations, leaving them vulnerable to the long-term risks of climate change. The court also set a substantive standard for the state's action on climate mitigation, demanding that climate policies going forward be grounded in science and international standards. It gave the state 18 months to integrate new interim targets into the climate law. This was a huge victory for the climate movement, marking the first time that a court in South Korea acknowledged that the climate crisis is a fundamental rights issue. However, the court rejected the plaintiffs' request to assess the adequacy of specific emission reduction targets and their claim that the 2030 target violated constitutional rights. The justices found that there is no universally accepted method for allocating global climate efforts to individual countries, making it impossible for the court to determine whether the target is adequate or not. While they may have put the ball back in the legislature's court, the justices importantly also added that this decision does not mean the state is doing its best on climate mitigation.
Overall, it was undeniably a big victory because it was the first time that the climate crisis was acknowledged as a fundamental rights issue, and the court ruled the law unconstitutional, so it was sent back for enhancement. But initially, the fact that the court rejected to rule on the NDC itself came as a big disappointment because some courts has taken specific target into their purview and they have ruled that they are unlawful. But on a grander theory of democracy and separation of powers, what the court was mindful was that they are not the elected power. So these political questions, these more technical questions, in their view, should be left to the political branch or democratically legitimate branch and decided. In that way, it will be able to be built upon a wider social consensus. So in a way, they were really respecting the democratic legitimacy and the democratic process. And whether that decision, whether that choice of the court was a reasonable and a justifiable one, it depends on what happens from there on. If the National Assembly of Korea and the government of Korea takes that decision and comes back with a better and a really robust target, the trust that the court gave to the democratic institutions are justified. But if they fail to do that, the court may have given too much trust to the political process, and we may have to go back to the court saying, well, As you can see, this is not enough.
The Constitutional Court stated that the new reduction target must reflect South Korea's responsibility in light of global reduction efforts. The court's ruling effectively gave Sejong's team and the plaintiffs more leeway and more authority to campaign for stronger action on climate change. With the deadline to submit a new emission reduction plan approaching fast, they got to work immediately after the verdict to calculate South Korea's fair share of emissions and an adequate target. They decided that the government should commit to reducing emissions by at least 65% from 2018 levels. But talks with lawmakers were abruptly paused when South Korea plunged into political chaos in December 2024, when then-President Yoon Suk-yeol shook the world with his brief failed attempt at imposing martial law.
저는 북한 공산 세력의 위협으로부터 자유 대한민국을 수호하고
Days later, President Yoon was impeached, but protests shook the country for several months after that, effectively halting Sejong and the plaintiffs' efforts to lobby the government for a stronger NDC. Things have since calmed down, and a snap election in June was won by the opposition. The newly elected president, Lee Jae-myung, has kicked off a pivotal new chapter for climate action in South Korea. His government is the first to promise to accelerate the phase-out of fossil fuels and scale up the share of renewables, which to date still make up 9% of South Korea's energy mix. 60% of electricity still comes from coal and gas, two fossil fuels that scientists have blamed for this summer's record-breaking temperatures in the country. South Korea just had its second hottest July on record, with the capital Seoul setting new records for tropical nights. Climate scientists said the extreme heat was made at least 5 times more likely due to climate change, and warned that continued fossil fuels will drive more frequent and intense weather extremes. With the deadline to submit a new plan looming, we can only hope that last year's ruling, a more climate-aware population and this summer's record-breaking heat, will inspire stronger action by the government. When Sejong accepted the Youth for Climate Action's case, there were no legal precedents on this matter. 6 years on, climate litigation has grown exponentially, with hundreds of ongoing cases worldwide and around 100 framework cases challenging national and subnational governments' approaches to climate action filed worldwide. As of the end of 2024, just over 40% of decided framework cases seeking more ambition or implementation of climate laws have been successful before the courts. The Korean Youth Climate Litigation ruling is one of them. At home, the constitutional ruling has opened the door for 2 subsequent cases, filed in February and March. But last year's ruling impact extended well beyond South Korea, with new ongoing lawsuits in Taiwan and Japan.
Taiwan started their youth climate litigation to their constitutional court in January 2024. That was before the decision of our case, but now that we have it, their case is just very much empowered because this was the first victory outside the European continent. And they can argue this is not just about Europe, this is truly global. Japanese case was filed in August 2024, right before the decision was rendered. And they are suing coal power plants and power companies in a civil court, but they were arguing fundamental rights, constitutional rights. So Korean case is, of course, a very important precedent because the legal system between the two countries are quite similar. Climate litigators around the world are working quite closely to each other because in every jurisdiction, it's a first-of-a-kind case. So it's very natural that international collaboration becomes very important because we cannot just rely on domestic precedents to argue these type of cases. This is a new challenge, a challenge that law, this classic perspective of law hasn't really anticipated. And new challenges require new theories and new responses. And having more of these responses and decisions from other countries are becoming really, really important. And of course, our case was only possible because we had precedents in other countries. So I'm really hoping that a Korean case could be a trigger point for a broader and a wider judicial victory around the region and actually beyond.
Undoubtedly, recent court victories have reinforced climate litigation around the world. And just last month, the International Court of Justice issued a historic ruling outlining the obligations of states in respect of climate change. It was everything climate activists had hoped for, and even more, and its impacts promised to be wide and far-reaching. But in recent years, and particularly in recent months, the rule of law is being challenged on and again. So before letting him go, I asked Sejong whether he's confident that climate litigation is really the most important instruments we have to hold polluters accountable and ultimately to secure climate justice.
One of the biggest realizations I had after this litigation was, at a certain point when you're too deep in the litigation, it really feels like when you win this, everything will change. But that's actually not true. It's only a part of the picture. In like democratic theory, it's only 1/3 of the picture, what judicial branch can do. And there's a certain limit to it, and there's a reason to that. So rule of law is there to provide the protection of the minority being the future generation in this specific case. And having the court to rule on that gives us a safety net or a floor that cannot be breached. So it really raises the bottom line. But bottom line is not what we're going for, and that's what we need. We need to go to what's scientifically needed, and all that space between the bottom line and what is scientifically needed is a matter of politics, the democratic process. So when we have the litigation as an important tool, it's just a tool, and we need that movement. We need the people to get on the street. We need the politicians to speak more. We need the corporates to act more responsibly. And we need consumers to push the corporates to act responsibly. All the other elements need to be there together to make the actual change. So the fact that we have discovered this judicial tool, a legal tool in the past 5 years, I think it's a great discovery and a great development, but it actually shows how much more movement and how much more democratic change that we also need to actually make this into reality.
Thank you for listening, and see you next time.